Hi everyone, I'm Brian T. Bradley and I'm an asset protection attorney. And you may or may not have heard me talk and lecture on, different wealth and protection shows and different podcasts and investment shows, as well as maybe some continuing legal education seminars. I'm the senior managing partner of Bradley Legal Corp. I'm also of counsel attorney at Lodmill and Lodmill, the leading expert in advanced asset protection and strategic planning, and an advisory board member and lead attorney of the Asset Protection Council. But I want to spend a few minutes talking and breaking down LLCs, limited liability companies, the pros and cons and everything in between, and why it's important eventually to go beyond the LLC. And this talk is going to be geared towards affiliate attorneys in our network, as well as potential clients and people just trying to learn about asset protection. And remember, we are measuring the tools up against those four considerations: ECCC, effectiveness, cost control, and compliance. So let's break down the LLC. This is going to be fun. When it comes to asset protection, we have different layers. I'm from the mountains in Lake Tahoe. We get lots of snow. I lived in Michigan. I live in Oregon now. Cold dampness. We obviously learn how to dress in layers. The first layer in our asset protection world, it's your base layer. It's generally made from merino wool and it sits tight on your skin. This is your LLC. And then you want a mid layer, which is usually a little bit thicker, and it can be, a synthetic wool, or for, you ladies, a cardigan. This would be, your limited partnership. And then when you want an outer shell waterproof layer, this keeps you nice and dry and warm when the weather is really cold and bad outside. This is eventually your asset protection trust or bridge trust. But by layering, you're now more flexible. When it gets hot and you're skiing or ice fishing, you can take the outer layer off, or the inner layer off, or the middle layer. You can adjust and make yourself more comfortable. The same thing applies with your asset protection plan. The base core layer at the foundation is your LLC. So let's start with this base layer foundational LLC in charging order protection entities. The LLC is a great first layer, and it's the entry place to start. It's the foundation along with insurance. LLCs are great asset holding companies, and they have some charging order protection that don't allow the creditor to, seize the assets of the entity. They limit a creditor's access to a charge against the member or the partner's interest on that LLC only. So they're great for real estate. We place things in them that have keys or that can go boom, things that can hurt people, and things that you need to go and get, liability insurance for. We want to place all the risky assets into an LLC, but you want to separate asset holdings from operations and operate your business dealings out of another LLC called an operating company. So if you're considering just the first entry level protection, because maybe you or your client, they're just starting out investing, their net worth is under $500,000 of net asset, and they only have anywhere from like 0 to 2 units. You should consider at minimum setting up 2 LLCs at this point. But by using LLCs, what you're doing is limiting some of their personal liability and separating ownership, use, and control. Now, if you're trying to protect just a few assets and money for the client or for yourself is limited, you're tight on your budget right now, the LLC and insurance is a great place to start. Now, even though I love LLCs and we use them to place the risky assets in, like, real estate and investment properties, and we use them to segregate assets into, or to put car collections in, or your yacht or your airplane. And yes, these are great first layers of protection, but everything has kryptonite. And when you talk to Superman, kryptonite's not good. And as attorneys, we need to understand the pros and the cons and be able to explain them to our clients, so that then the clients understand the need to layer up as they grow and when they hit that level and why. And so the LLCs lack on efficiency. Just remember, they're what's called maybe protection. And it says it straight in the name: first word, first letter, limited. They do not hide that fact. And since most of us already know about LLCs and what is good about them, this is where I'm going to spend some time talking about the negatives that you're not told with LLCs, so that you understand the limitations and the need to layer as the client grows, or as you and your assets are growing. For real estate, we generally use the state that the asset is located in. I see some people recommend using one of those other states that are, good for LLCs, like Wyoming is really popular, or Delaware, Nevada, to hold real estate in. The reality is that, like, it's okay. It's not a wrong thing to do. But if you have an investment property, and let's just say Tennessee, and it's held in a Wyoming LLC or a Delaware LLC, it's fine, but if you're sued, through that Tennessee property and you have a lawsuit against that LLC, you can be very certain that the Tennessee court's going to be applying Tennessee law in that LLC that's holding that Tennessee real estate, not Wyoming or Delaware law. So if you think that you're buying another state or jurisdiction's better laws by having an out-of-state LLC own an in-state asset, I don't think that that's true. And you can't be certain about that either. And that's not good. Lack of certainty is not good for asset protection. So we typically just say use an LLC in the state that the asset is in or the boat is registered in. And we also like to separate assets out. We don't want to use too much, put too many assets or equity in one LLC. So you're going to have to cap how many assets and properties you're going to put into one LLC at a time. For example, I had a California resident with 5 investment properties, all over 1 million. Each property was each worth over 1 million, and he put all of them in one LLC. Then they got a multi-million-dollar mold claim. So now all those assets are at risk because they're all stuffed in one LLC. So what you want to do is take $1 million property and separate them out into their own LLC. Now, if the equity is lower, let's say, $100,000, then you can probably place 4 of those properties into one LLC. Another problem generally is that most clients come to me with, 15 LLCs, and they're all either single member LLCs or multi-member LLCs, and they're all, disregarded entities and all in the client's personal name as the member. Now we have a problem from an asset protection standpoint because the courts have a tendency to disregard those single member LLCs held by an individual, meaning, you or your client. And CPAs tend to set up LLCs as disregarded entities for tax purposes. That's great for taxes, but it's very bad for lawsuits. Or a common trend is that the CPA will set up an S corp for real estate. And that's another bad thing to do, when it comes to real estate. One reason is because S corps have shares, and those shares can be frozen or seized by a judge. And same with the C corp. And I actually get this a lot. A client coming to us, with real estate and an S corp, and it has 100 million worth of real estate all within one S corp, or it can be other assets like, for example, truck beds. And from a liability and asset protection standpoint, it's not good. We would prefer to move those assets out of the S corp, but we wouldn't want to at this point in time without the client having to pay a huge tax recapture fee to the IRS. So now we're basically stuck. And this could have all been avoided if the planning was set up properly from the beginning to grow with, possibly by having the client, the CPA, and the asset protection attorney all talk together and then separating the assets out of the S corp, from the very beginning, not even putting them into an S corp and owned by a different entity like an LLC, and then just operating the business out of the S corp for tax purposes. But to get back to being disregarded, there are pros and cons. What an LLC being disregarded means is that the IRS is not taxing the business separate from you. It passes through to you personally. And because of this, they're basically worthless for asset protection and liability issues because that liability also passes directly through to the client, to you. So you always need to understand the difference between tax mitigation strategies versus asset protection strategies and be able to explain the difference to the client, or just you, the client, need to understand the difference. A lot of possible clients are going to be coming to, you as the attorney, or, you're going to be coming to your attorney thinking, and expecting that you're moving assets for both protection from creditors and to not pay taxes. But you need to understand that, asset protection planning is tax neutral, and we're setting up the planning for protection purposes from possible lawsuits and creditors, not to avoid paying taxes. What you actually want is for that single member LLC that's holding the risky assets to then be owned not by you, the individual, but by a second layer of protection, which should then be a multi-member limited partnership, not another LLC. That second layer should not be a Wyoming LLC most of the time. And I'm going to break down the benefits of the limited partnerships later in a different video. But by doing this, what you're now doing is properly layering the protection. This mid layer, the limited partnership, will be owning all those LLCs that are holding all your clients' real estate. And so all those LLC tax filings and K1s will simply passively flow directly through the management company. So the client will just have one tax filing. And again, it's important. And you're most likely going to be having to not just win over the clients, but also the CPA and the financial advisors who have no clue about any of this. And so what we're doing is maintaining the legal protection, but we're disregarding them for tax purposes, creating a smooth and easy transition for fewer tax returns by adding that second layer, the limited partnership. It really just comes down to how you use them all together. And the second big misconception people have with LLCs is just, where do you even go to set these things up in? Do you go to Delaware, Wyoming, Texas, Nevada? Well, it really, in reality, just comes down to an issue of, what are the clients holding and where are you holding it at? But I think, I just covered that pretty well, in the beginning, which is realize that, let's say, for example, is California real estate, and you set up a Wyoming LLC, and then you bring it to California by holding a key piece of California real estate in it. And now the client is also being, paying the franchise tax in California because they're a California resident. What you have just done is, you converted that Wyoming LLC to a California LLC because they're doing business in the state of California. And so just realize you can't buy another state's better laws and take them to another state. For real estate, it doesn't work like that. And then we have a big misconception here when it comes down to the new person on the block, the new kid in town, the series LLC. They're very young with no case law to rely on. And only a few states actually have series LLC statutes and legislations. And so what this means is that if you have a client that lives in a state that does not accept series LLCs and doesn't have a statute for them, like California, and if your client purchases, let's say, real estate in a different state that doesn't recognize that structure, they won't get the benefit out of the series LLC. And so again, they're just getting a false sense of security. So I only recommend and like series LLCs for clients that live in the state that recognizes the series LLC statutes, and also the assets are in them as well. And again, only as a base layer protection. And then I would never put in an asset that does not exist in the state that does not have series LLC statutes. Those will go into their own separate LLCs. And then we have the big final misconception of LLCs. And this is the word anonymity. And the thought here is that, you can just create an anonymous Wyoming LLC and just poof, disappear, and the client can never be found, that the LLC member's name is not available to the public. And because of this, that they can just completely avoid or like ghost a lawsuit. And this is just completely false. But this is what your clients are hearing on, investment groups and summits, and what they're hearing from promoters and even some attorneys. And so this is what, they are expecting. And so these people do these, big, long talks, on hiding assets, and though they may not be technically lying, if you get a judgment against you and you get called into a debtor's examination in court, you are the one that's going to have to tell them, you are the weak link in the line of this secrecy, so under oath, you, the client, are going to have to tell them that, yeah, I set up a Wyoming LLC, and now your privacy plan just completely exploded on you. Privacy is fine, but secrecy and hiding is not. Wyoming LLCs have their place in the asset protection world as a first line of defense, for business owners, for privacy and not placing yourself at risk of harm or harassment. But it's a privacy mechanism before lawsuits start. Wyoming and Delaware LLCs and out-of-state LLCs require what's called personal agents of service. Their sole job is to serve the client and tell them, congratulations, you just got sued. Now go get yourself a defense attorney and defend yourself. The simple reality is that once a lawsuit is filed, the discovery process, of litigation begins, and then you will be served, you will be subpoenaed, and you will be forced into court. And what's even worse is that if you want secrecy to even work, also known as lying under oath, that's a one-way ticket to jail. And an example of this is, what I mentioned above, that very shortly after a judgment is entered against, a person, creditors have the legal right to demand information about the assets that you own. And the courts enforce this right very broadly. So at this point in litigation, the only way to keep an asset anonymous or a secret is to lie about them and commit perjury. So for assets that are real estate, we recommend using the state that the real estate is located in, because again, you're not gaining anything by using another state. You're just doubling your maintenance costs. You just can't buy another state laws, for out-of-state assets. So just keep it simple and then add layers to that protection system as the client grows or as you grow and your assets scale and grow. That's where the limited partnership would eventually come into play. Just remember, the weakness with LLCs is that it's still just maybe protection, and it's used more as a deterrent. Maybe it will be upheld, maybe not. Maybe the judge will pierce the veil, maybe not. There's just a lot of uncertainty with LLCs, and uncertainty is not good, especially when strength and power is important. This is where a full and diversified asset protection plan that is properly layered and really comes into play. This is where we go beyond just the LLC and start adding the second and third layers with the asset management limited partnership and the bridge trust. This is where these two components come into play. My recommendation would be to email me for a consultation, and we'll go, do a full risk assessment and, asset evaluation, see what layers and level you're at. Then we can determine what tools you need to get, for yourself. That's going to give you the confidence and comfort that you're looking for. My email is Brian, BRIAN @btblegal.com. And my email is www.btblegal.com. And I hope that you have a better understanding about, like that first foundational layer piece and the importance of layering as you grow. And my purpose of this is just to try to clear up a lot of this confusion on all these different tools that we have. Take care and thanks for listening.